Hi, Erin. Welcome to the podcast. How are you?
Doing well. How are you?
Doing fantastic. I'm excited just to have a attorney on here who actually can talk about real estate, hopefully give some advice. So Erin is an attorney who's licensed in North Dakota and Minnesota, primarily focusing on real estate planning, and probate. And so really excited to have you on the podcast here today.
Absolutely. Glad to be here. Thanks for inviting me.
You're welcome. So we figured we would jump right into it. And there was a couple different questions. We're going to go to it on maybe some different things, from evictions to lease agreements to contract for deeds to maybe option agreements, on working both sides of it to kind of be impartial, to try to advocate for both sides, whether it's the landlord or the resident or the buyer or the seller. So if we wanted to start with that, looking at kind of the do's and don'ts of maybe the first one being like a rental agreement, just like a standard landlord tenant. Any suggestions on both sides of like what you should or shouldn't either have in there, do, or negotiate when you're looking at a lease agreement?
Yeah, absolutely. So I'll jump into that. First thing, lawyers, we always have to give a disclaimer. So I'll jump in quick with mine to start this podcast, just so that everybody watching knows this is just for educational purposes only. It's intended for general information, not specific legal advice to your situation, your specific facts. And so you shouldn't take any action based on this. You should talk with an attorney that's aware of your situation before you make any type of decision. As right now, I can't really make an attorney-client relationship with any of you watching, although feel free to ever give me a call if you need something. With that out of the way, jumping into rental agreements. So that's kind of a big one, that there's a lot to unpack there. So kind of talk about the biggest thing that I always tell people, 100%, the number one rule is everything needs to be in writing. And that may seem really elementary, but it doesn't happen quite a lot. And that can range anything from people won't have any lease, which is not good. It's not good for the landlord. It's not good for the tenant, to only certain things are in writing. So part of it's in writing, part of it's, oral and it's not in there. And I will tell you, it says more for the tenants specifically, but if it's not in writing, it doesn't exist according to the law. Is kind of how we generally treat that. So if you have some type of protection that you want to have, especially as a tenant, you need to have these things in writing, and you need to find it in your contract and make sure it's in there.
And why, if I can jump in, if I get back all the way to, I'm gonna butcher the terminology, but like common law, where people would like make a verbal and handshake and then like, oh, well, verbal is binding. Well, maybe, right? Like everything kind of has this context. Like, yes, you sign this document, and then like, why would you have partially on the contract and the other part of it being a verbal, like, oh yeah, by the way, I'll give you your security deposit back, or like, yes, you can buy this property for X amount, but if it's not in writing, it just becomes that much harder to prove, I'm assuming, in a court.
That's exactly it. That's the whole reason why we have, most of the time, oral contracts can be enforceable in some situations, but they're not. And specifically regarding for the sale of an interest in land, which has to do with real estate a lot, those must be in writing. An oral contract for that is unenforceable, so there are specific exceptions where it can't be. Otherwise, it just really goes back to that simple, he said, she said, then a judge has to decide who's telling the truth. And quite frankly, they may or may not get it right. And so the law just says, you know what, if you can get it in writing, do it. And there's also clauses, I will tell you. So this is getting a little into the weeds on that, but a lot of times leases and other contracts you're signing are going to have clauses that basically say, if it's not in this agreement, it doesn't exist. So for example, the easy one I always give is you go and you buy a car and you're talking with the salesman and he's trying to get you to buy the car. And he says, I'll throw in free tire, brand new tires on there for free. If you sign a contract that every other term is in there, the tires are not in there, and nothing's included on it, and it has this clause that I'm talking about, it's unenforceable. If you would go to a court and say, he said he was going to give me free tires, they would say, sorry, contract says nothing about that. You don't get to enforce it. So It's just really a landmine to not have it in writing.
That makes a lot of sense. So rule number one, get it on paper.
Absolutely. And if somebody says it's in there, right, again, this kind of goes for tenants too still, but if somebody says, yeah, no, it's in there, it's probably on page 2 or something, have them show you or find it yourself or get an attorney to find it for you, just to make sure that it is in there.
Sure.
Some of those clauses that we want to talk about, there's a lot. I went through and it was like, well, what clauses to talk about? There's a lot. So I'm going to give you kind of a smattering of them, explain what they are, and then what you want in each situation, whether you're tenant or landlord. A big one that's always important is the default clause. I kind of start with that because that's usually the important one. Default is when you do something that is against the lease. So as a tenant, what I always recommend when I'm reviewing a lease for a tenant, I always want to make sure that there is a clause that says if the tenant is in default, they have to get notice before the landlord can terminate the lease. And again, it doesn't have to be long. I never push for like a 30-day just because I don't think that's reasonable. But even just a week for like non-payment, because, sometimes things happen, right? The check gets lost in the mail or something crazy. The notice requirement is just nice because everybody's on the same page, especially as the tenant. And in Minnesota, I will tell you, usually there's no notice required by law, even in residential evictions. So before a tenant gets evicted, a lot of times in Minnesota, there's no notice required, generally speaking. North Dakota, it's only 3 days. So you have a little bit of protection. Sometimes in North Dakota, I'll kind of let it slide with the 3 days because it's still getting the point that I want, but still, I really recommend that for tenants, just so that they have notice, they have an opportunity to cure whatever that default is. So if it's a default that's non-payment of rent, I might just say 7 days. If it's a default for any other reason, sometimes it can be, depending on the lease, parking in the wrong spot or pets or something, maybe it's 30 days to cure.
So maybe talking through that default scenario just in a little bit. Let's say for one reason or another, whether it's the landlord's fault, it's the tenant's fault, I paid you, no, you didn't, you should be parking there, you shouldn't be parking there. Let's say that there's a dispute. And now it's like, okay, this thing is going to elevate because of this default clause, or the landlord's like, oh, I'm going to execute this. What does that process look like?
Meaning when they're disagreeing about whether it happened or not?
So like, he's like, you're in default of this. What would be the landlord's or the tenant's response to that? Is that where it's like, oh, he's like, you're in default, so I'm going to give you the 3-day notice so that you can go to eviction, and then we're going to schedule a court hearing, and then we're going to go through that route. Whereas the tenant might be like, well, I've paid you, here's my proof, like you can't do this. But regardless, like they still, if the landlord's pushing it through, might still have to go to the court. Just maybe talking through whether or not they agree on the default, and maybe the different paths that you see, or ways that has gone historically.
Absolutely. So depends on what the default is, right? Non-payment of rent, that's usually not going to happen most of the time, because that's going to be as simple as the tenant providing the cancel check, right? That says, hey, it was deposited as of this date, whatever. Sometimes we do see those default clauses coming into play for other reasons. Sometimes it's the parking. That's kind of one that I mentioned where, parking is required in certain spots, or certain repairs or maintenance are required, and that wasn't getting done. Those sorts of things. Usually I don't see those go to court, just because there should be kind of a straight way that that's determined one way or the other, or at least they come to some type of an agreement. Usually it's the non-payment rent that come into play, and those just don't, there's usually no disputes one way or the other. But if they do, we've had the ones where you're exchanging letters back and forth, trying to, yes, we did, no, we didn't, here's how we prove it. Thankfully, I haven't seen too many of those escalate, but that's again why we do the notice thing, because sometimes a tenant doesn't even realize that they're in default until they get the eviction complaint, and then all of a sudden, then they're trying to prove all of these things, and now they have a looming court date as well. So that's why the notice thing is a really great thing to have for the tenant. For the landlord, in the default clause, I always recommend that you call out specific breaches of the lease in addition to late payments, right? We all know that paying the rent late, that's a default. But I'm seeing a lot more, especially with Minnesota, with the eviction moratorium that we've had, this is come into play a lot more. In residential, you need to have specific provisions that say, hey, if we get a police call for your unit, it's a violation of your lease. You are in breach of the lease automatically if we get a police call. You're in breach if we get noise complaints. In breach if, an unauthorized pet, an unauthorized person there, whatever. Some of these things are covered by statute. So it's not, if you don't have it, it's not covered, but a lot of them aren't. And it's just really nice. It'll tell you to be able to point that out to the judge when you're in an eviction action, getting them out for that reason when, yeah, they're really causing issues, use your imagination, other tenants really don't like those things. And so you're getting other tenants that are threatening to leave because of these. And so you can just point to this and say, judge, this is a violation. This has happened twice now. We're asking for eviction because they absolutely have breached the lease. So good things for landlords to do on that. Kind of along the same lines, a bigger one that I'm seeing, this is more commercial. If you're doing some type of commercial lease, but having a use clause, so what the premises is allowed to be used for. If you're doing a commercial lease with someone, you want it very clear that this cannot be used for residential purposes, right? Because you don't want this to turn into some type of residential lease, as well as putting in specific exclusions as the landlord. I've had clients that have storage units, and they're specifically calling out and saying, you cannot operate a repair shop out of this. You cannot operate any business of any kind. This is literally for storage only. Those are really important things to have in there when you have a tenant that decides to put a bunch of abandoned, broken down cars in front of your space. And now it kind of looks like a junkyard. So very important for a landlord, I say now to have. As a tenant, obviously you want that as broad as possible, but really, you just need to make sure that whatever your purpose is for the premises, that's included. Otherwise, along the same lines, exclusivity clauses. This is one that is not talked about a lot, but is so important. Again, more in the commercial side of it, not in the residential. As a tenant, so you're operating some type of business in a strip mall, for example. If you are doing that, you need, to me, this is a non-negotiable, you need to have an exclusivity clause that says, if I am operating a smoothie shop, I am the only smoothie shop in this premises. There's been big issues. I've had multiple issues on either side of this becoming in there. So as a tenant, I say this is a non-negotiable. It has to be there. It will ruin your business if it's not. As a landlord, I guess I look at it as fine either way, because again, as a landlord, I don't want the tenant to fail. I want the tenant's business to thrive, because that means they're going to be able to pay me rent. So the downside is you have a bigger pool if you don't have exclusivity. But again, to me, that's such a short win. In the long run, I think you're hurting yourself.
So maybe just as a general for the listeners, if you're renting out something and it's residential versus commercial, or maybe owner occupied versus non-owner occupied, or because I've heard of people doing like retail arbitrage, where like they'll rent it out and then they'll do Airbnb with the home, or you're leasing them out a commercial space and they kind of convert it into like there's an apartment up here, then there's business down here. Maybe just is there different, like, clear black and white lines between owner occupied, non-owner occupied leases, or is it kind of, as long as both parties agree, then you can kind of do whatever this landlord tenant relationship looks like?
Yeah, I mean, I think if both parties agree, you can do whatever needs to be done. It just, again, comes back to, you need to look, farther, right? Are you okay with those different allowances going into the building, right? Are you okay if all of a sudden this turns into, an Airbnb or a residential, kind of going back to that use clause? are you okay with that? And most of the time as a landlord, I would say no. I would make
Mhm.
it as small as possible, because then you set the expectation.
Sure. Well, I imagine it's kind of funny. We were doing a little prep call, and where Adam likes to wing things. Erin's like, got these prepared documents. You can tell that you're a true good attorney, because you got like your talking points, your points, and going through all this stuff. And I want to be sensitive of your time too.
Sure.
We had maybe a couple other things, and then if we want to, we can maybe circle back to kind of the standard ones. There was one we had talked about just in general about like evictions and how they're handled with like moratoriums and maybe do's and don'ts. Do you want to segue into that for a little bit?
Absolutely. Yeah. So evictions, this is speaking. So I'm licensed in North Dakota and Minnesota. So I'll really kind of focus generally on those two states and those laws as far as it goes. Most people know there's been an eviction moratorium in Minnesota since the pandemic began for residential evictions. That did bleed over into commercial evictions. I could spend a lot of time on the unintended consequences of that eviction moratorium, but I won't bore you with that. We'll save that for later. Otherwise, North Dakota did also have an eviction moratorium for a little while. I believe it was only for a few months. Then they were back up and running. And so as of right now, currently the landscape is evictions are allowed across both North Dakota and Minnesota, residential and commercial, for any reason at all. The only exception is right now, Minnesota will not allow an eviction to proceed against a residential tenant who has a pending application for rental assistance. There's a couple different emergency rental help options that tenants can apply for. And so if they have a pending application, if they are trying to get rent help, then they're not going to allow the eviction to occur. That's the only exception as of right now. Otherwise, it's kind of back to current law with its own nuances.
And it's a good point too, because I don't know how many people knew of rent help. Like,
Yeah.
landlords can tell their tenants about it to help the landlords get either current payment or back payment. And I've heard there's been some
Yes.
differences between North Dakota and Minnesota. But then if I had to think about kind of like a little hack, not that we're want to encourage malevolent behavior here, but if you're applying for, rent help or assistance, like, that could potentially help bridge your financial situation or being kicked out by next week Friday or whatever the term would be. So I think that's a pretty good tip.
Yes. And so it's really important, they're trying to make it as easy as possible for tenants to do that. So, anything that you can find, it really is a benefit to both the landlords and the tenants. That's really how they're trying to push that, especially with the landlords. And this is important for landlords to know too. Rent help will only pay for back rent when a tenant is still at the premises. So if you go, someone is behind 18 months and you go and evict them because now you're able to in Minnesota, if you get them out and get them evicted, rent help will not look at an application after that because they're no longer there, right? Their rent help's whole goal is to keep people in their unit. So it's really become where we have a discussion, when a landlord calls me, we bring that up and we talk about it and say, are you okay with that? Is it more important that this person needs to be out, maybe because of those other issues that we had kind of talked about, noise complaints, police calls, drugs, whatever? Is it more important for them to be out, or is it more important for you to get paid, and will they follow through? We are having the issue though. There are certain tenants that you can lead a horse to water, but you can't make them drink, and know that there is some options for landlords in that situation. I have two currently where the tenant has a pending application. They applied and were given that protection. They have failed to respond. They have failed to do anything on the application, and months have gone by, and then the application does get denied. So know that you're not just kind of stuck here in limbo, at least indefinitely. You will be for a little while, and again, they can always apply again, which would make it pending, which would make it difficult. So know that is still kind of an unknown in Minnesota, but there are some limitations on that. So do what you can. I mean, work with your tenants. even before the pandemic, we always had the discussion, attorneys are expensive, right? To bring an eviction action. If you have an entity owning your real estate, which I always recommend, right, for that separation of liability protection, it's again a whole nother rabbit trail we could go down. But if you have an entity that owns the property, you technically do need an attorney to bring that eviction action because it's not you personally. And we're expensive. So evictions are expensive. They are time consuming. They are a faster process, but I won't say that they're as fast as any landlord would ever want. And so if you can work things out with a tenant, if you can set up a payment plan, if you can, quite frankly, figure out a cash for keys instance, you pay them $500 if they will get out and have the place cleaned by next week, you're better off in the long run. And I'm telling you this as someone who gets paid when it doesn't work out. It's way better for everybody. Then the tenant doesn't have an eviction on their record, which makes it really difficult to rent. Then you're not paying probably somewhere $800 to $1,200 for court costs and service costs and attorney's fees. And you're not waiting, 3 to 4 weeks for the court process to go through. Everybody's just a little bit happier in that instance.
That's a great tip. And I know and it speaks to Erin, to your character too, of just trying to help people out and just sharing, hey, even if you're not the right solution, like, hey, this is probably a preferred solution, like similar to what we offer. It's like, hey, if you can go get a bank loan, that's way better than, if you can do a lease with an own, because your payment's gonna be lower. You have a fixed, 30-year, but it's for those situations where maybe that you can't resolve to that solution and where you need to bring in some legal expertise or go kind of a different route.
Definitely. No,
anything else so we were kind of talking about the moratoriums and how those were a little bit unique. Anything else specifically on evictions that from like either do's or don'ts or lessons that you would share on if someone's either going through it or thinking about it, either on the tenant or the landlord side?
Honestly, what I would say, there are a ton of resources online for both tenants and landlords. This would be where I would give that plug, and I'll maybe kind of name some of them off, but you can Google, right? I mean, Google really is helpful. I use it. So, no hi-hat here. I just always recommend, if you can find a resource that references the state statutes of your state, just because you can find anything on Google. I mean, if you want to try to do something, you can find something to back you up. So we really want to make sure that you're actually following the rules that pertain to your situation. So the easy one is contact an attorney. But if you're trying to find some answers, look on Google, find something that references the statutes. Minnesota courts has a ton of resources for landlords and tenants. They lay out the forms, they lay out the process for a landlord that's going through an eviction. So check out the Minnesota court website. That's very important. North Dakota has the same thing. There's also, I'll give this plug, it's for another attorney. His name is Lawrence McDonough. He is kind of one of the names in Minnesota for evictions, kind of more on the residential side and more for tenant help. And he has a wealth of information on his website. I'm pulling it up here. It's povertylaw.homestead.com. He teaches at a couple law schools in the Twin Cities. So you'll see some of those resources, but take a look on there. He has so much information and is so helpful. Cases, statutes, everything that you would want. I use that resource very often, and so no qualms about sharing that. And it's more geared towards the tenants, but I always tell landlords it's so helpful because, again, this is what your tenants would be using. So why wouldn't you take a look at this and make sure that you're doing everything right? So that's a huge resource I recommend. There's things like Homeline, which is homelinemn.org. They have a ton of resources, especially with the eviction moratorium in Minnesota. They've been way up to date on that, which is great. The Secretary of State website for both North Dakota and Minnesota, they're going to have tenant rights. So again, much more geared towards the tenants, but as a landlord, double check that, make sure you're doing everything right. And then the other one that I do look at every once in a while, North Dakota has, it's the American Apartment Owners Association. They have just some quick references to, again, state statutes that govern certain things with leases. So very helpful as well. So I would recommend anytime you're looking at evictions or leases or anything, those are huge resources that you can have right at your fingertips.
And so when you talk about state statutes, you're talking about like North Dakota, and I think like the website's like North Dakota Century Code, it'd be like 18.2.4-7 or whatever it is. And you can like go to that and be like, okay, the security deposit cannot exceed blank, and the rental agreement can do this. And it's like, you have to give 3 days. And so although some of these, whether it's Google, Minnesota courts, these other kind of free, they've probably taken out like the 30 pages of legalese and tried to be like, okay, well, here's how I would explain it to a fifth grader. But still there's legal statutes that say, okay, for all the situations, like this is what you have to apply. But then there's probably some things where it's like, well, what if it's not in state statutes? And it's like, okay, so there's maybe, 60% of the lease is covered in the state statute, but then it's like, oh, well, what are we supposed to do if this comes up? And sometimes, if we segue into some creative deal structuring with like option to purchase agreements or contract for deeds, it seems like those are a little bit more unique, where there's still some law, but it seems like it's not quite as I would say black and white, because it's not as common. If we segue into there, any comments on like just how option agreements or contract for deeds can be handled, or in the eyes of an attorney, or from the landlord tenant buyer standpoint?
No, that's exactly the best point that I can make on it is those resources are wonderful for most situations. If you have something that's not black and white, that's not clear, you need to talk with an attorney. Like, and again, that is not a biased response. That is, I always use the doctor analogy, right? If you have a minor headache, you can probably figure it out yourself, take some Tylenol, be good to go. If you're, having a huge lump that shows up on your arm that's turning purple and doing weird things, Google is not going to help you, right? You need to go to a doctor. And people recognize that. We all understand that. I am one that goes to the doctor because I trust them more than Google. So it's kind of the same thing. If you have a simple situation, you can probably figure it out on your own. I will help you find the resources. If it's more nuanced, you need to find an attorney, get some legal advice. So rent to own and contract for deeds are absolutely in that category. I really do recommend you need to talk with an attorney, whether you're the one purchasing it, the tenant side, or the one who's financing it, the landlord side. So let's kind of talk about in general. I think most people know what they are, but some of the benefits, drawbacks of them that I think are important to go over in general. Rent to own. So as the purchaser, you are still just a tenant. You have no further rights than that. When you have a rent to own option where you're paying, the normal $500 a month or maybe a little bit more, and at the end you're credited a certain amount that's going to go towards the purchase price. You're just a tenant. So you can still be evicted. You're still subject to the same rules, but you're also subject to the same protections. So it's helpful and hurtful. You just kind of need to know where you stand. Obviously, it's helpful because you don't need as high of credit. But the big things that I will tell people that are looking at this as the tenant purchaser option, inspect the property. 100%. This would be the time where you get an inspection done before you sign that rent to own lease agreement, because you're usually taking it as is, right? You're going to live in that property. You're going to know it. So if you're making a sizable like down payment, for example, or if you're really, expecting to be in there for the long haul and want this money to count, you need to make sure that if there's going to be big issues later on, right? What is the roof like? What does the roof look like? What does the boiler look like? All of that sort of thing. Same thing with an appraisal. This is something people don't always think of, but I would highly recommend getting an appraisal done of the property so that the terms that you're agreeing to for the purchase price, for interest, for everything else, that it makes sense, that it's in your best interest. It might be a little bit higher because again, the financer, the landlord is taking a little bit more of a risk with you. It's a little bit different of a strategy, but it should be somewhere in the ballpark that it makes sense. Along those same lines, remember it's kind of like signing the purchase agreement really early on. So you need to make sure that you understand the terms of the sale, like the date, what the actual purchase price is, what are the terms of that? There's probably going to be some more costs at closing, such as, recording the deed, the title inspections, all of that. So make sure that you've prepared for that and you've budgeted for that. Look for title issues. Does the financer actually own the property? That's kind of a big one. And unfortunately, they make bad names for this sort of thing where people say, oh, this is a terrible strategy. It's not. But you need to make sure that you're working with somebody that actually owns the property, that if they have other debts on the property, so if they have a mortgage on the property, that it's, less than what you're going to be paying for it, and that they are paying for that mortgage so that you're not out anything if they were